Hi, I'm Luke Nichols with the law firm of Nichols & Green, and I'm going to talk to you about 20 speeding ticket defenses. Now, I watch hundreds and hundreds of speeding trials every year. I'm in court probably 200 days a year, and about half of all the cases I defend are traffic related. So I'm in traffic court all the time, and I watch people stand up and try to defend themselves and pitch all sorts of interesting and varied defenses. So I'm going to talk to you about 20 of the most common and effective speeding defenses. Some of them are good defenses, some of them are bad defenses, and some it depends on how you use them. So I'm going to go over the pros and the cons and how to use these defenses and when to use these defenses. So the most common defense I hear is continuing the case and hoping the officer doesn't show up. Now, this may work in other jurisdictions, but it doesn't work in Virginia. The reason why is each officer is assigned one court date a month to prosecute all of the tickets they write for that month. If the officer doesn't show up, it's not just your case that goes out the window, it's a month worth of work that is gone. Officers can get in big trouble with their supervisors, they can affect their career, they can even be held in contempt of court if they just don't show up. So officers rarely don't show up in Virginia. And when they don't show up, it's often because of a family emergency or a law enforcement emergency, or they're sick or something like that. And in that case, they can just call the court, and if it's a bona fide personal emergency, the court will just continue all the cases to the next date. So it's rare to have a situation where an officer doesn't show up and doesn't have a good excuse. Typically, this is only when the officer leaves the police force. One of the most common excuses I hear in speeding cases is, I was going with the flow of traffic. Now, this typically isn't a very effective defense. Judges hear it all the time, and it usually doesn't do much good. What's more effective is to get a copy of the dash cam video of the police officer's cruiser. And while the video will not show any speed readings on there typically, it will show whether or not you were going with the flow of traffic. So if you can put the dash cam video in and it shows you going with the flow of traffic, then all you have to do is ask the officer, well, how fast was traffic moving at? And they'll typically say something like 5 to 10 miles over the speed limit. And so that shows that you weren't going any more than 5 to 10 miles per hour over the speed limit. Because if the video shows you were moving with the flow of traffic, and the officer says the flow of traffic was 5 to 10 over the speed limit, you couldn't have been doing 15, 20 over the speed limit. So that's the more effective way to use that argument. Arguing that your speedometer is broken can be helpful, but you have to understand how to use it. A broken speedometer is not a defense to speeding in the state of Virginia. So it doesn't get you out of trouble completely. It's mitigating evidence, which means evidence that you aren't as blameworthy, that you shouldn't be punished as harshly. It's not evidence that you're innocent. So what you do is you go out and get a speedometer calibration. You take your car to a mechanic. They typically put the car on a device called a dynamometer, which spins the wheels. And then you can compare the speed on the dynamometer with the speed on the speedometer. And the mechanic will write up some sort of calibration certificate that says, at this speed, the car's speedometer reads this, and at this speed, the car's speedometer reads that. Yeah. And you take that to court and present the certificate to the judge to prove that your speedometer is inaccurate. Typically, if your speedometer is low, meaning that your speedometer reads lower than your actual speed, you can use that as mitigating evidence to convince the judge that you should be cut a break. Attacking the calibration of the police officer's speed measuring device is probably one of the most effective ways to outright win a speed case. However, it's also one of the most technical and most challenging ways to do this. So basically what happens is that the law in Virginia says that an officer needs a calibration certificate if they're going to try to introduce some sort of speed measurement. So whether it's a pace, a laser case, or a radar case, there's some calibration certificate associated with that speed measurement, and that officer needs to bring that calibration certificate to court. There's varying laws that govern how you can introduce into evidence calibration certificates, and these are very technical laws. And if the officer doesn't follow all the technical requirements for admitting that certificate into evidence, you can kick out the certificate. And if you kick out the certificate, the officer doesn't get to testify to what the device said. This is a very effective method for beating speed cases, but it's also a very technical and complex way to beat speed cases. Even attorneys who are not experienced in doing speed enforcement cases struggle with this sort of thing. So doing it on your own is pretty tricky. Needing to use the bathroom is one of the most common excuses for speeding. Now the problem with this excuse is that most of the people who use it didn't have an accident when they got pulled over. So here's the problem. If you speed to go to the bathroom and you get pulled over by the police who write you a ticket, it takes more time to get to the bathroom than if you just obeyed the speed limit. So if you can make it to the bathroom without having an accident, even after being written a ticket, then you could have just driven the speed limit and been fine. So if you really had to go and so you were speeding down the road, if you had an accident, that's a pretty legitimate excuse. It sounds like, it's still not a defense, but it's a good, it's a very sympathetic excuse. If you were speeding to get to the bathroom and you didn't have an accident despite being pulled over by the police, well, at least acknowledge it to the judge and say, well, I felt at the time that I wasn't going to make it. I wasn't sure at the time, and in hindsight, I really should have slowed down and just gone the speed limit, but that's why I did it at that time. In traffic court, a lot of people try to justify their speeding because of an emergency. Their wife was having a baby, they got a call that somebody was in the hospital, they were trying to catch their flight, they had to be work or they're going to be fired. Something really big was happening that justified their speeding. If you're going to go down this route, make sure that your excuse really justifies the behavior. The higher the speed, the better the excuse needs to be. Additionally, you have to explain why there wasn't a safer, law-abiding way to accomplish what needed to be accomplished. Why couldn't you just call an ambulance, or were you really going to miss your flight? Things like that. If your excuse really doesn't justify the speed, admit it to the judge. Tell them, listen, at the time I felt this was really important and I got overly focused on needing to be on work on time or catching my flight. I know speeding is dangerous. I should have just slowed down. I should have left the house early, and this is not how I'm going to deal with these emergencies in the future. And that's really important. When you go and tell a judge that you were justified in what you're doing, that's the same as telling him, I'd do it again if I could. Okay? And judges don't like that. They don't want to hear that I'm going to keep speeding, that I don't think I did anything wrong and I don't need to change. So if your excuse wasn't a really good one, make sure you make it clear to the judge that even though I felt it was a big deal, I'm not going to do this again in the future. Sometimes you don't have an excuse. You just know that you're right and the officer's wrong. If you're in that situation, don't get intimidated. That's okay. This is a legitimate defense. But here's what you should do. First off, get a calibration certificate that shows your speedometer is accurate so that you can get up and testify and say, I saw my speedometer, I was doing 55 miles per hour, and here's a calibration certificate that shows my speedometer is accurate. Second, write down everything that happened and everything that you said to the officer and he said to you. Keep a detailed record of everything that happened about the case. Little details. What was the weather like? What was traffic like? Draw a diagram about where you were in relative to other cars and the police officer. What did the officer say to you? What did you say to him? Write this all down and preserve it so that when you take the stand, you have notes that you can reference to refresh your memory. Third, talk to an attorney. Almost every attorney I know, myself included, does free consultations. Call us up. We can give you a lot of free advice. And you never know, you might end up using our services. And the fourth thing, try to get a dash cam video. Okay? A lot of police cruisers have dash cams. You can use that to see what you were doing relative to other cars, and it can often be used to help back up your story. To be guilty of speeding in the state of Virginia, the speed limit sign has to be properly posted. There's three ways that a sign is not properly posted. One is the sign gets obscured, either by vegetation, tree limbs, other signs, it gets knocked down. The other way is that it's not actually a speed limit sign. Those yellow signs that have speed limits on them, they're yellow and black, those are advisory signs. They're not actual speed limit signs. So if you go onto an off-ramp and it has a yellow sign, that's not the speed limit. That's not an official speed limit sign. Sometimes officers get that confused. The third way is sometimes local governments or local organizations will kind of go vigilante on us and they'll post their own signs. If you can find out who posted the sign, you can find out whether or not they had authority to do it and whether they did it according to the law. So those are the three ways we attack whether or not the speed limit sign was properly posted. Many jurisdictions will dismiss or reduce your charge in exchange for a driver improvement course. However, each jurisdiction has its own rules and regulations about how they do this, or even if they do this. For example, Fairfax County in Northern Virginia doesn't do this program at all. Prince William County does. Arlington County also does it, but they require a very specific Arlington County course, and there's very particular rules about how and when they do it. Talk to a local attorney or talk to your local county clerk's office to find out if that program is available and what are the requirements of that program. Believe it or not, people go to court and argue that they were speeding because they were running out of gas. A lot of people think, oh, if you're about to run out of gas, go faster in order to get home quicker before you run out of gas. Of course, this isn't a great idea for a couple reasons. One, it's not a very good excuse for putting people's lives in danger and speeding and breaking the law. And two, if you go slower, you actually save gas. So by going fast, you run out of gas quicker and your car runs less efficiently. So if you didn't know that, don't use that one in court. You can do a lot with a good driving record. You're going into court and just saying, hey, I've never been in trouble before, I've never gotten a ticket before, I have a clean record. That carries a lot of weight on minor traffic infractions. In Virginia, a +5 record is a perfect record. Anything between a 0 to a +5 is a good record. Right around -2 to +3 is kind of average. From under -2 to about -4 is not so great. And if you get a -5 or below, that's pretty bad. If you're a -10, you're going to shock people. And my personal best is I once saw a -54 record. So yeah, having a good record can really help. Oftentimes you can just ask, cut me a break because of my good record. You can take a driver improvement class in the state of Virginia to receive 5 good points to your record. You can do this voluntarily at any time, and you can do it once every 2 years. It costs about $45 to do it online or about $75 to do it in person. If you don't have a perfect record and you'd like to improve your record before trial, you can take the driver improvement class on your own and get those 5 good points added to your record. Many people are caught speeding while they're trying to pass someone. And often they go to court and use this excuse or defense and it backfires at them. The reason why is it doesn't work very well if you're accused of speeding more than about 10 miles per hour over the speed limit. Here's the reason why. First off, the question becomes, how fast was the person you were passing? How fast were they going? If somebody's already going 10 miles over the speed limit, you really don't need to pass them. All right? They're already breaking the law. Why do you need to go even faster than they are? Okay, if somebody's driving the speed limit, you don't need to drive 15 or 20 miles per hour over the limit to pass them. Okay, so what happens is if you're accused of speeding more than 15 over the speed limit, it doesn't really make sense why passing them is an excuse. Okay, now this isn't always true. There's special circumstances where it could be the case, but you have to think it through. One of the most effective ways to beat a speed case is to attack how the officer did their job, how they used their speed enforcement equipment. This is the most common way we win cases where people are accused of going over 100 miles per hour. However, it's a very technical defense and it requires a lot of experience and a lot of technical training. You have to understand the science and the methodology behind all of the equipment they're using. You have to understand how they were trained. You have to understand the NHTSA enforcement methodologies. And you have to understand the rules of evidence and the legal maneuvers necessary to exploit that information. And it really takes a technical background with a focus in speed defense. But if you have an attorney who knows how to do this, it's very effective. It's just not the type of thing that you can do on your own without years of experience and a lot of training. A lot of people get caught speeding as they're coming down a hill. Now, this can be a good excuse. Saying, hey, I really wasn't meaning to go that fast. It was just, I was coming down a hill and I picked up a little extra speed. This works particularly good if you're accused of just going like, 10, 15 miles over the speed limit. The important thing is to know where the officer measured your speed. Most officers like to measure your speed with radar or LiDAR as you come over the top of a hill, right as you're cresting the hill. They do that because you don't have a chance to slow down when you see the officer. They get you right as you come over that hill. Other officers will sit there and measure your speed and tag you as you get to the bottom after you've picked up a few miles per hour. So find out which of those things your officer did before you start arguing that he measured you at the bottom of the hill. Sometimes we speed to get away from unsafe situations. There's a drunk driver, someone tailgating us, an aggressive driver, but we have to make sure that our driving behavior is justified by the situation. Obviously, if you're driving 90 or 100 miles per hour to get away from somebody who is tailgating you a little bit, that doesn't really make a lot of sense. So this defense works best at lower speeds. So if you're accused of going 10 or 15 miles over the speed limit, maybe that makes a little bit more sense. Additionally, you have to explain why you couldn't just pull over or let the person go by, why speeding was the necessary way to get out of the situation. Sometimes it wasn't, and you just admit it to the judge. Say, listen, Your Honor, this guy was tailgating me and I accelerated to get away from him. I wouldn't do it again if I had the chance. It was a poor decision at the time, but that's why I did it. Sometimes we speed to get away from somebody who looks like an aggressive driver and it turns out to be a police officer. Police officers will come up in an unmarked car and tailgate you, and you keep accelerating to get away from them and they keep following you and it's creepy and you don't know what's going on. I explain that to a judge. Try not to be accusatory or pointing the finger at the officer a ton, but just explain, hey, I didn't realize. I thought this was some creepy guy and I was just trying to get away from him and he kept following me and I got scared. I didn't know what was going on. And sometimes that can be a legitimate defense. When a police officer writes you a ticket, it's really common for there to be errors on the ticket. Most of the time, these errors have nothing to do with your case and they're not a defense at all, but sometimes they are. If the officer wrote down the wrong address for the court, the wrong time for the court, that's a big deal. Talk to an attorney immediately about that before you go to court. If the officer wrote down the wrong name of the person accused, that can be a big deal. If he simply misspelled your name, that's usually not a big deal. Additionally, there'll be little biographical information like your height, weight, eye color, or the make and model of your car. If these details are wrong, it's usually not too big of a deal unless there's a genuine issue of whether or not the officer pulled over or ticketed the correct person. A lot of people get ticketed for speeding because they're behind the wheel of a car they're not used to. They drive an older, slower car, and they borrow a friend's car or get a rental car that's just peppier, it's smoother, it has better suspension, and they don't realize how fast they're going. This can be a really good explanation, especially for low-level speeding offenses. So if this is your situation, tell the judge what car you normally drive, tell them what car you were ticketed in, explain to them how you just weren't used to the feel of the car. This is particularly effective if you were alone at night or on an empty road and there was nothing really around to gauge your speed with. Ignorance is not a defense to speeding, but it's not irrelevant either. If you didn't realize how fast you were going, explain it to the judge. Explain to them why you didn't know. So if your speedometer is accurate, present that information. If you're driving a car that just goes faster and feels slower, tell it to the judge. If you're in a car that's higher off the ground, like a pickup or an SUV, often it just feels slower. If there were no other cars around to kind of gauge your speed, explain it to the judge. These things can all be relevant. However, things you don't want to say are, I didn't realize I was going that fast because I'd taken some medication and it was making me kind of loopy. That's a DUI, and that sounds really unsafe. You don't want to say that. You don't want to say, I didn't realize I was going that fast because I've been working 15 hours straight and I was really sleepy. Saying I was sleepy and speeding, not a good idea. So make sure that your explanation of why you didn't realize you were going that fast isn't worse than the accusation of speeding. If you're in this situation, take a driver improvement class before court and then tell the judge how taking the driver improvement class has made you better at being aware of your speed and better at avoiding accidentally speeding. If you look up traffic defenses and speeding ticket defenses online, you'll find a lot of material from organizations and people calling themselves sovereign citizens. These arguments take a lot of different forms, but they all basically say the same thing. The gist of the argument is that the courts and the police officers don't have the authority to enforce traffic laws or even write traffic laws for that matter. They often cite very arcane laws and cases that don't really have anything to do with traffic laws. And these arguments rarely, if ever, work. I've never seen one work in my entire career, despite the thousands of cases I've seen. Another traffic ticket defense that's become quite vogue online recently is the right to travel defense. This defense revolves around the idea that you have a constitutional right to travel. and that as long as you're not engaged in commerce, the government can't regulate how or when you drive. Therefore, laws requiring you to get license plates, have a driver's license, or obey speed limits, that those are all unconstitutional because they infringe upon your right to travel. These arguments are incorrect. They misunderstand our constitutional rights. First off, you do have a right to travel. However, you do not have a right to drive a car. Driving a vehicle is not a constitutional right. It is a privilege, and the Supreme Court of the United States has ruled that over and over again. So you may have a right to travel, but driving a car is not the same as traveling. You can travel without a car. Additionally, just because you have a constitutional right doesn't mean the government can't infringe upon it. I have a right to privacy, but the government can still search my house if they have a search warrant. I have a right to own a gun, but the government can still require me to get a permit before I can conceal it. So just because you have a constitutional right doesn't mean the government can't infringe upon it. It just means that they can infringe upon it only when it's reasonable to do so, and the infringement is outweighed by a pressing public need. In my entire career, I've never seen the right to travel defense work in a speeding or traffic ticket case, nor have I ever heard of it working in a traffic ticket case before. So if you're going to try this, you can, but it's not something I recommend. Well, hopefully this video helped you out and you learned a little something from it. If you have a traffic ticket in Northern Virginia, or if you have a question about a traffic or criminal case in Northern Virginia, call our firm, the law firm of Nichols & Green, for a free consultation. If you have a traffic ticket or criminal matter in someplace other than Northern Virginia, call a local attorney. Most attorneys will do free consultations. At any rate, thanks for watching, and if you'd like to see more legal videos and more information about your rights, click subscribe to the Nichols & Green YouTube channel. And if you ever have a traffic or criminal matter in Northern Virginia, call us for a free consultation. Thanks for watching.